Good morning, DZRJ, 8:10 a.m. The Voice of the Philippines proudly presents Piracy Watch with attorney Sarah Jane Sugitan, exploring the concepts of intellectual property rights and protection, teaching you how to protect what you create. And now, here's your host, Sarah Jane Sugitan.
Hi, good morning everyone. Welcome to Piracy Watch. Again, we'd like to thank the Intellectual Property Office of the Philippines for bringing this program, the first and only radio show dedicated to your copyrights, trademarks, and patents. For some news, the Intellectual Property Office of the Philippines opened its 9th satellite office in Tuguegarao City, Cagayan Valley last Friday. IPOPhil Director General Attorney Ricardo R. Blancaflor graced the launch at the DTI Region 2 headquarters. IPOPhil is now located in 10 cities nationwide, namely Baguio, Cagayan de Oro, Cebu, Davao, General Santos, Iloilo, Legazpi, Pampanga, Tuguegarao, Cagayan, and the headquarters here in Makati. All trademark and patent applicants need only to go to the IPOPhil offices or log on to www.ipophil.gov.ph. Joining me this morning is the head of the arbitration office of the IPOPhil, Attorney Lope Manuel Jr., who took up his master's in law in innovation, law, and policy in Toronto, Canada. Hi, Lope. Attorney Lope.
Good morning, Sarah.
Good morning.
Yeah,
okay,
how are
we're
you?
going to talk about the arbitration office, the newly opened arbitration office of the Intellectual Property Office, in order to help you litigants speed up your dispute resolution. Is that correct?
Yes.
Yes, speed up your dispute resolution and come up with a settlement that is favorable to both parties. You know, intellectual property is mainly a commercial phase to it, and parties that go into litigation usually have monetary issues involved, monetary concerns, and when someone copies their brand or their patented invention, they usually want the other party to stop using it, or at least use it in accordance with the authorization that the plaintiff wants to happen, more or less. So the arbitration center is going to help litigants settle their disputes more speedily and how should we say it, more amicably. Okay, so I'm bringing you Attorney Lope. Attorney Lope, what is arbitration and how is it an alternative to litigation?
Okay, yeah. Good morning, Sarah. Good morning, everyone. Arbitration is actually part of the ADR mechanism of the Intellectual Property Office. ADR means Alternative Dispute Resolution. It includes mediation and arbitration. Mediation is sort of coming up with a settlement agreement. You sit on a table, talk about your differences, and come up with an amicable settlement. And if you cannot agree, you go to either the regular route of litigation. In the IPO, we have the Bureau of Legal Affairs, or you go to the Office of the Director General for an appeal, or you choose the arbitration, which is more or less similar to litigation, but there are differences in a way that you can choose your arbitrator, meaning you can choose your judge, the person that you trust you can appoint the person that you trust as an arbitrator to rule on your conflict. And it's different in also because you can schedule your hearings. You can schedule your hearing in the Philippines, outside the Philippines, in Cebu, in Davao. It depends on your preference, and it is non-appealable, meaning if, for example, there's a decision of the arbitration panel, you cannot go to the Court of Appeals, you cannot go to the Supreme Court. It's final.
Okay. So let's break it down a little bit. For all of you there who have pending cases in the Intellectual Property Office, it's usually a trademark cancellation case, or
Yes.
a patent cancellation case, or just plain unauthorized infringement or use, and or licensing. Even the license agreements also fall under the scope of the Intellectual Property Office of the Philippines. Now, usually when there is copying involved, parties go to the IPO or to courts for a case. So you file a case, and that really can take a very long time, ladies and gentlemen. And the IPO is offering alternative dispute resolution mechanisms, such as there are two ways to go about it: mediation
yes.
and arbitration. And this morning we're talking about arbitration. Now, Attorney Lope was saying that it's different from litigation in the sense that you get to pick your judge or your
Yes.
arbitrator, you get to set your own hearing dates,
Yes.
and you get to choose the venue. So
Yes.
so unlike, for example, in a normal ordinary criminal proceeding or civil collection case, you file it in for example, in Manila or in Makati, you file it in the regional trial court or in the municipal trial court, whichever the case falls under, and then you have to go there and cooperate with the court whenever the judge is free, diba? And usually the judges, our courts have substantial amount of backlog in terms of dockets.
Yes.
And even in the IPO, we also have should we say backlog, because we have to, of course, there are many proceedings, there are many tactics involved in discovery, or usually the litigants come from abroad or are foreign corporations. So,
Exactly. Yes.
So it's hard for lawyers here to get, for example, evidence, or I mean, it takes time for evidence to come in from abroad in order to prove the allegations in a particular complaint. But with arbitration, this is also agreed upon by the parties.
Yes, it's contractual. It is based on the agreement between the parties. We cannot really force them unless, for example, they have a contract before and there's an arbitration clause in the contract. That means that you really cannot go to court directly. You have to go to arbitration. And it usually happens in the Philippines through a construction contract or a distribution agreement. But now we're pushing, for example, here in the IP, like for example, you come up with a licensing contract with a local distributor. Sometimes, or most of the time, they force you to come up with an arbitration clause in your contract. And this is an option for you as a local distributor, as a local businessman, to say we can do the arbitration in the Philippines because we already have arbitration in the IPO. Unlike before, they will insist on arbitration in Singapore or Hong Kong.
Because that's the default venue.
Yes, that's the default venue. If I may add also, Sarah, another major difference is that if you're a foreigner, you can be represented by a foreign lawyer. In the Philippines, we have limitations on legal practice of foreign practitioners. They cannot just appear in court. In the arbitration, they allow you to be represented by someone from another country, with, of course, a limitation that they cannot appear in any other court but that. Because this is a consensual, this is a contractual thing. So you want to be represented by someone who's familiar with your case.
Definitely, the legal practice in the Philippines under the Constitution is limited to Filipino lawyers, or at least Filipino citizens. So this is an exception to that general rule, wherein we allow foreign lawyers to appear on behalf of clients who have interests here, but only for that particular proceeding.
Exactly, yes.
Okay, and arbitration is contractual in nature, meaning you have to agree to go into arbitration, or at least it must be stated at the onset in a contract, for example, trademark licensing or patent licensing. For example, I'm a licensee of, for example, Playboy, and I violated terms of my contract. I can settle, or I can put forth that case in the IPO through the arbitration mechanism.
Yes, that's true.
Here in the country, because we have that capacity to do it
in
now.
the Philippines now, yes. Before,
previously, no.
Yeah, we don't have that. So, for example, Playboy in the US would insist on arbitration, for example, in Hong Kong or Singapore, or sometimes in London or New York. And the Philippine lawyers would, the best that we can do is to lobby for an applicable law, which is most likely US law or California law, where we are familiar. But now we can lobby also on the venue. We can say it could be done in the Philippines because you can choose your lawyers here, you can choose your arbitrator, you can bring in a foreign arbitrator if you want, and we'll facilitate it. It will be as effective as it was, or as it will be held, for example, in China or in other jurisdictions.
In Asia, which countries have arbitration capacities? Because this is not normal. I mean, you have to build up a capacity for that country to be an arbitration center.
That's true. In Southeast Asia, there's Singapore, and Bangkok is doing it now, but they're not really, they're not matured yet. They haven't matured yet. So we're pushing it, and the thing is, we are partnered with big groups here, like established groups like the Philippine Dispute Resolution Center Inc., which is headed by former Chief Justice Panganiban. So you have a very good name backing the system, and reputable people other than him would be Dean Custodio Parlade or Attorney Boy Lasatin of Accra. These are big names in the legal practice, and they're pushing this hard. So we can be confident that you know exactly what we're doing, and that the people behind it have a reputation that they cannot just throw away in the garbage.
Okay, we're going to get back to Attorney Lope and this revolutionary way of settling.
We now return to Piracy Watch on DZRJ 810 AM. The voice of the
All right, welcome back to Piracy Watch. You're still with me, Attorney Sarah Jane Sugitan, and joining me this morning is the head of the Arbitration Office of IPOPHIL, Attorney Lope Manuel Jr. Just before the break, we were talking about what is arbitration and how it is different from litigation in the sense that litigants, or at least the parties, conflicting parties, can choose their judge or arbitrator. They can choose the venue and the hearing dates. Okay, so let's go back to that topic, Attorney Lope. You said earlier that arbitration is contractual, but for pending cases, is there an option for the parties at any point in a pending case to go into arbitration?
Yes, arbitration can be a post or pre-conflict contract scheme between the parties. Like after the conflict, even after they have filed their case in the IPO or in the court, they can still enter into an arbitration agreement. And in the IPO field, we have prepared a specific or a specifically designed arbitration contract for them that they can sign, which will be effective anywhere they go in the world. Incidentally, I'd like to inform everyone that we, the Philippines, is a member of the New York Convention, which means that an arbitration award issued here in the Philippines can be enforced in any country that is a member of the New York Convention. And as far as I'm concerned, most of the countries around the world are members of that. So this also means that, for example, an arbitration award issued in New York should be enforced in the Philippines as well. So that means that because of this arbitration scheme in the IPO, we are part of the global infrastructure that if we issued an arbitral award here, it can be recognized in any country, and with the consent of the parties, it can be published in a legal journal in a country, which can be a basis for international law.
For example, let's take a big trademark like McDonald's. It has
Yes.
franchisees in the Philippines, and for example, any one of that franchisee violates a specific agreement in the license or in the terms of the franchise, meaning of course there's infringement, or at least there's an authorized use of the trademark or maybe the recipes behind the burger. Can McDonald's enforce? McDonald's, the main franchisor, can opt to go to litigation, sue that franchisee here in the Philippines,
Yes. Go to arbitration. I would imagine, Sarah, that by business practice right now, most of the commercial lawyers listening here would agree with me that they put almost all the time, an arbitration clause in their contract. So, for example, let's say that they put an arbitration clause saying that the arbitration will be in the Philippines using our arbitration rules. Incidentally, the arbitration rules of the IPO were based from WIPO. So this is a very reputable arbitration rules which can be trusted anywhere in the world in terms of IP related cases. So for example, they have a case like that, they can either go to the court, they can go to IPO if there's no criminal action, or they can go to arbitration directly. They can still go to the special commercial courts in the Philippines, and after a while, if you feel that, oh, maybe I want to go to arbitration, they can eventually push to an arbitration. I would just caution everyone that if there is an arbitration clause in the contract, you cannot go to litigation directly. You have to go to arbitration first. And then
So
you have to settle your disputes there.
So it's a precondition to litigation
Yes.
if there is an arbitration clause in a commercial contract.
If there is an arbitration clause, usually, if there is an arbitration clause in the contract, you have to go to arbitration. And then the only time that the court will determine if, or will enter the picture, is when you're requesting for provisional remedies like injunction or something, maybe an assistance in getting the witness to appear before the arbitral tribunal. Or when you want to enforce the award, if the other party is not very happy with it, they want to question the arbitral award, or they want to wait, they go to the court to enforce the arbitration agreement award. And because of that, most of the time the court will not look into the substantive issues. They just look into the procedural issues, like if there's a violation of equal protection or due process. But this is very, very rare
It's rare.
instance. Like in the experience of the construction industry in the Philippines, most of the cases are enforced. Most of the arbitral awards are enforced. They rarely go to court for enforcement. But sometimes here in the Philippines, the lawyers will always push for delays, especially if you lose. You want to save your client's money, so you question every aspect or every detail of it. But good luck, because right now the Supreme Court has ruled that we must respect the arbitral proceedings, and we must honor our commitment in the New York Convention to enforce arbitral awards.
Okay, let's go back to arbitrators. You said earlier, arbitrators they are sort of judges. I mean, we can say
Yes.
that they are judges. Who chooses, and is there a certified list of arbitrators that parties can choose from? Or,
Yes. In the IPO field, we did an accreditation program for the arbitrators, and we invited IP lawyers, IP experts, and arbitration experts